Hi, class. Today is Monday, April 27th for you. Again, I always record these a little early. This is day 11 of our civil rights unit. So we've got a couple weeks worth of stuff done. Remember, if you've seen that video that I posted Friday about the announcements, you don't have to worry about any of those assignments from before. Those were hold harmless assignments that could only help your grade. But starting with this week, I'll be adding things to the fourth quarter. And that's going to be a little bit more of a traditional quarter. So you want to make sure you keep up with these notes and lectures. Test is probably going to be sometime next week. I mean, I'll give you at least a week's notice. We're looking at late next week is my best guess at the moment. So today, we are going to continue with those court cases. So, our objective today is to describe how the Supreme Court decisions of the 60s could directly impact you. And a lot of these decisions really could have a direct, immediate impact on your life. So, let's pick up where we left off on the notes from before. And from before, we had talked just about one of the cases. And you're going to need to write all these cases in your notes. And essentially, I don't really want it to be this way, but the reality of a test that I'm going to give you online is that it's basically going to be an open notes test. I really can't stop you from looking at your notes, but it is timed. So you're only going to have 45 minutes to do it, normal class period, which means you don't have a lot of time to be flipping through your notes. So you want to have this very organized when you're ready to take that test. You want to have all these notes available to you. So that first case you'll need to know is Baker versus Carr. So just to review, that's the one that said legislative districts had to be roughly equal in size. Otherwise, it was really disproportionately overrepresenting rural areas and underrepresenting urban areas. A little boring, but actually very important. These other ones you might be a little bit more familiar with and are less, I think, a little bit more interesting for a lot of you. And the first one is Engel versus Vitale. Now, I always remember this one because I think Engel looks like angel. It's close. And this one's actually about school prayer. So, this decision. So, we're starting right here. These are our first new notes for today. This said school-sponsored prayer was illegal. Now, there's a very fine line there. So what this means is that I, as your teacher, I cannot, in a public school, say, okay, I'm really worried about this air test. Everybody gather around and pray. Because it is not my job as a public school teacher to direct you to one particular religion or another, or religion at all for that matter. Now, it does not prohibit school prayer. It prohibits school sponsored prayer. So in other words, if we were getting ready to take a test and at your desk you wanted to say a prayer, I didn't direct it. You wanted to say one to yourself, you could. Now, there are some exceptions, and again, it's always up to the Supreme Court to determine where that line is. You know, is it precluding you from, is it a 45-minute prayer that makes it so you can't do anything in class? Well, that might be a problem. The basic idea is that you, as a student, you have First Amendment rights. Technically, your parents possess them for you, but you have religious freedoms. So if you want to wear a cross, for example, you certainly can. But if the school tries to impose something on you, like a PA prayer, and you get detention if you don't say this prayer, that is where that line is drawn. So another example would be if I'm teaching in advanced placement US history, I will talk about religious movements. And I'm allowed to talk about anything to do with religion as long as I'm not advocating one as being right or wrong. So I talk about the creation of the Mormon faith, or I might talk about historically how Catholicism and Protestant faiths had conflicts. That's no problem. What I can't do, I could even pull out the Bible to illustrate some points about that, especially that'd be easier in world history. What I can't do is pull out a Bible and say, this is the truth, or the Quran and say, this is the truth, and then, make you read passages from it to inspire you. That one is where you can't go that route. You could use it as a historical reference and say, this version of the Bible influenced the Protestant Reformation or whatever it might be. So that's where that line is. School sponsored prayer is illegal. And it's pretty straightforward from there. And that was in the 1960s. This next one, I bet you've heard of, although it's very misunderstood, and I blame Medea. Okay, Miranda versus Arizona. So, Miranda versus Arizona is a very famous court case about Ernesto Miranda in a situation where I believe he was picked up for some sort of theft or robbery. Now, what the police didn't know at the time was that he had actually committed, I believe, a sexual assault. And he asked for a lawyer, and they told him, "You're too poor to have a lawyer," and didn't inform him that, technically speaking, the Sixth Amendment says you have the right to a fair trial, which includes an attorney. Uh, and so he said, "Okay, I confess," and then confessed to a crime, a much more serious crime that they had no information or anything, any idea that he had committed. What the Supreme Court then said was all suspects must be made aware of their constitutional rights upon request. We now call that your Miranda rights in, reference to this landmark case. So you've heard the Miranda rights before in Law and Order or whatever TV show. Hopefully, that's the only place you've heard it. You have the right to remain silent. Anything you say can and will be used against you in a court of law, so on and so forth. Those are your Miranda rights. Now, what's very unclear, what people confuse all the time, is that if you are not read your Miranda rights, it does not mean you get away with the crime as shown in Medea. Although Tyler Perry's a very savvy businessman, I don't believe he is a constitutional lawyer. So let me explain. I'll make the suspect me. So I'm accused of robbing a bank, and before they've read my rights, I say, "Yep, I robbed that bank. I loved it. It was a good time." And then they hurry up and read me my rights. And then they say, "Did you rob that bank?" And I go, "I'm not going to say anything until I talk to my attorney." They can't use my confession that I had just made before I'd been read my rights. But if they have my fingerprints, if they have video of me robbing the bank, if they found all the money in my house, they could still use all that evidence against me. So even if somebody forgot to read somebody their rights, all it means is anything they said could not be used against them. The video, the witnesses, the purple dye packing the money, all that stuff, all that can still be used against you. So, very important distinction. If I had confessed and they hadn't read me my rights, they couldn't use that confession or anything else I had said, but they certainly could still use the other evidence. All right, Roe versus Wade. This is the other case I think you might have heard of. Roe versus Wade is probably one of the most controversial decisions we'll talk about. It is a 1973 decision that gave women the right to have an abortion. Now, there are limits. States can set different limits, but for the most part, if you are an adult woman of sound mind and you are early enough in your pregnancy and you decide that you do not want that pregnancy, you have the legal right to have an abortion. Now, that has probably been the most challenged decision over the last 40 some odd years. That is something that really divided the women's rights movement because, the women's rights movement, just like everybody else in America, is split on this issue. Some see this as a women's rights issue. Some see this as absolutely a pro-life issue. Again, as your teacher, I'm just explaining to you the case. It says that if you are of sound mind, you may have an abortion. There are allowed to be reasonable limits. It can't be too late into the pregnancy. Uh, Different states have different laws about minors, how old you have to be, or if you have to have parents' permission. But generally speaking, it is legal. Now, again, it's a very controversial decision. Before I do this last case, let me flip to this page that has a little bit of insight into a couple of these. So this is Ernesto Miranda, who was the one in the obviously Miranda versus Arizona case. Um, Not to be rude, but not a good guy. He ended up in jail, even though he got out of this particular offense. He ended up in jail soon after for another crime. And then he was a part of a group of three men, I believe, who broke out of prison. And the other two men who broke out of prison with him murdered him. So things did not go well for him. This is Norma McCorvey, who was known in the court case as Jane Roe. So she is the one who was suing for the right to have an abortion. She is now a pro-life advocate. And then we'll get to Alan Bakey here in just a moment. Okay, so your last court case, really for this entire unit, your last court case. Regents of the University of California versus Bakey. Now, I've had a couple different professors pronounce this different ways. Bach, Bakke, Bakey. I'm going to go with Bakey. You go with whatever you want. But this is a 1978 decision dealing with the University of California's medical school admissions policy. What it essentially said was they only took 100 applicants every year. And it was based on grades primarily. And Bakke has the 85th best grades going in. So in theory, he would have made the top 100. But the regents of this university, the University of California, said we are going to reserve 16 spots for the highest grades for minority applicants. So Bakke ended up getting just missing the cut because as the 85th person and a Caucasian, the other 16 spots were reserved for minorities. So what he sued for was that he felt essentially he was a victim of quote unquote reverse discrimination. Now, Mr. Birch always makes this point: discrimination is discrimination. There's no such thing as reverse discrimination. I understand his point, but understand the main point that throughout the overwhelming majority of time in history, discrimination has been against a nation's minorities. This, in this particular case, is called reverse because it is somebody who is in the majority of the population feeling that they are being discriminated against. The court's decision, though, is nuanced. It was a very close decision, but what they said was you actually can take into account these sorts of things. It just cannot be the overwhelming factor. So, in other words, when you apply for school, college or law school or whatever it might be, you often have these admissions programs that will assign basically points, and they might give you points for having been in band or been in choir or been a student council member or volunteer hours. This allows points to be awarded for being a minority because they're trying to make up for many of the wrongdoings of the past. It's just that that point value cannot be to the point where it exceeds the most important thing for a college, their academic progress. So it is allowed to be a factor still. And I will say personally in my own life, I had a roommate in college who happened to be Hispanic, and we were on the very same scholarship, except his GPA requirements were a little different than mine. It never bothered me because it wasn't my business. I worried about my money and he worried about his, and he was a good roommate, and that was that. But apparently, Bakke had issues with this. So it maintained affirmative action, which is essentially trying to have policies in place to help. It certainly doesn't completely, but help make up for some of the injustices of the past. A very common form of affirmative action we talked about during World War II, which is if you want a government contract, you had to have a minority population that was reflective of the minority population in your community. So if you had a business and in the county your business was in, it had 20% African Americans and you didn't have any on your staff of 200, it was reasonable for the government to say, hey, sounds like you're pretty discriminatory in your hiring practices. So we're not going to give you a contract unless roughly 20% of your employees are minorities because that's what it should be because that's the breakdown for your particular county. Okay, those are all of your notes for this section. So what I'm going to do is I'm going to connect two forms to this. We're going to connect the formative review, which I want you to do first. The formative review, remember, is always going to be not, well, it's not graded for an academic grade. Whoops, I skipped a section. That's okay. It'll be in the form. And that formative review will just review some of the questions. There we go. Some of the topics that we just went over. Then I'm also going to attach a graded Google form, which will be an assignment for 10 points due at midnight tonight. Do the formative first. Do this one first because that's practice that you can miss and be corrected before you do a graded assignment. Again, this grade will be on the fourth quarter, so make sure you take your time and let me know if you have any troubles with it at all. Okay? Have a great day, everybody, and be